Our next speaker is the chairperson of the legal committee of the Pittsburgh branch of the American Civil Liberties Union. He has litigated cases involving separation of government and religion, free speech, First Amendment issues, including the original case that went to the Supreme Court, the ACLU versus Allegheny County, which involved the display of an nativity scene on government property. So please welcome Jon Pushinsky, Esquire.
Thank you, everybody, and good morning. I hope you can hear me. I'm not sure whether this microphone's actually working or not. If you can't, start. Yes?
We can hear you.
Okay. Listen, I'm here today to talk about hobby lobby. Anyone who wants to buy a hobby kit. But there are a couple of things I want to start out with. First of all, what do I do as a civil rights lawyer? I spend my time, and have for 35 years now, to defend the 10 Commandments. Look at this expression. But the 10 Commandments that I defend as a civil rights lawyer start out with, Congress shall make no law. After all this time, I still find it somewhat ironic that the first 10 amendments to the Constitution are held up as the Bill of Rights. And I can't help but think, and have thought, that the Supreme Court, those 9 justices in black robes who ascend the bench from behind purple curtains, are the high priests of the American religion in the temple that sits on Washington next to the Capitol building. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And for the bulk of American history, those 2 clauses together have stood for the proposition that the American government does not favor one religion over another or religion over non-religion. So my work has not been to promote any particular religious or non-religious ideology. The goal of my work is to make sure that all of us, with the vast differences in belief systems, are free to work and to believe and to advocate without any type of government oppression or undue pressure from other individuals. The decision in Hobby Lobby, decided recently by the Supreme Court on the last day of its term this year, to me poses a great danger to the structure that I have just identified. And it represents a movement during the course of the current Supreme Court to involve religious thought more in the governance and governing structure of the country, and to erode that wall of separation that Thomas Jefferson found so important, and which we were taught of and about when we were in school. But before talking about Hobby Lobby, I had to bring up some more current events. Who here read Friday's paper? Pittsburgh Post-Gazette. Anybody see anything of interest there to the topics that we're talking about today?
In God we trust.
In God we trust. Now, Allegheny County, for those of you who are traveled, that's the county we're in now, like any other county in the state or the country, has pressing business matters. Public safety, eroded roads, finances, how to provide services to the people. And we hopefully elect public officials who will spend the time that we pay for as tax-paying citizens to deal with those pressing matters. But on Friday, we read about the Allegheny County Council that I guess has nothing better or more pressing to get involved in than to think about what type of inspirational phrases to put on plaques in the chambers of the government. And one of our county council members, who identifies herself as an evangelical Christian, according to the newspaper, has introduced a measure to put a plaque in chambers with the phrase, "In God we trust." And that evidently opened up some debate by other council members who were afraid that people like me might sue, I guess, if they did that. I don't want you to think that I just said I would sue, but they're afraid that people like me might sue, and perhaps I would think about it if one of you complained. But that's something to think about and talk about down the road. And I'm not saying that that is a meritorious case, and I don't know that anyone would bring it, but it certainly raises the issues that we're here to talk about. So to avoid litigation, one of the other council members proposed, well, let's put some other phrases on there. So now what they're thinking about is a plaque that says, "In God we trust," and they're going to put "E pluribus unum" on there. From the many to the one. Certainly these are phrases that appear on their money, a very godly physical object. But also there are other phrases that we're going to put up, and I found the whole thing very laughable because there's so much else that they should be dealing with. Who cares what they have on the wall? Is it going to solve our problems? Well, that's my divergence into, I just saw that in the paper Friday. I figured I'm talking here Sunday, I've got to say something. So, the case of Burwell versus Hobby Lobby. 5-4 decision with the usual suspects lining up the way we would expect them to line up. We have a majority opinion written by Justice Alito, joined by Roberts, Scalia, and Thomas. On the other side, dissenting, the primary dissent was written by Ruth Bader Ginsburg. Joined by Justice Sotomayor, Breyer, and Kagan. Breyer and Kagan also wrote a separate dissent. In the middle, so that's 4-4. In the middle is one justice, and it's the most powerful justice in the United States. Because those 8 justices, we can predict with relative certainty on an issue like this how they're going to line up. So at oral argument, when you write your briefs, the whole strategy is let's grab Justice Kennedy. And in this case, as in so many, he joined with Alito, Roberts, Scalia, and Thomas. Now what's Hobby Lobby about? What's Hobby Lobby? Hobby Lobby is a closely held corporation that is owned and operated by a single family that is extremely religious and attempts to operate the Hobby Lobby business according to the family's own personal religious beliefs and how they perceive their particular version of Christianity should operate. And they give a lot of money to charity, they fund missions, and they do all sorts of religious activities. But Hobby Lobby is not one family. Hobby Lobby is a for-profit corporation. Hobby Lobby has 500 separate stores around the country and employs 13,000 people. That's Hobby Lobby. 13,000 employees, 500 stores around the country. Now we move to the Affordable Care Act, which, as you all know, had a component by which employers have to provide insurance to employees, and that insurance is supposed to cover certain types of birth control at no cost to the employee, just as any other medical procedure would be covered by the insurance. Hobby Lobby objected to this provision in the Affordable Care Act because abortion violates the religious views, should we say, of the corporation. Certainly it violates the religious views of the family. And the family in this instance, they are the corporation. The Affordable Care Act provides certain exceptions to nonprofit religious organizations. And that's an accommodation that goes to, remember, that first commandment has two components: free exercise and establishment. And in order to accommodate the free exercise rights of certain religious entities, let's say mosques, synagogues, churches, for example, they can opt out of that provision of the Affordable Care Act by signing a particular form. And then the government steps in and provides that particular coverage to the employees. Hobby Lobby wanted to be treated the same as a religious institution. And so they sued to challenge the provision of the Affordable Care Act that required it to provide contraceptive coverage for 4 distinct types of contraception, which include, for example, the morning after pill, because the owners of Hobby Lobby believe that's an abortifacient. Hobby Lobby was not filed under the First Amendment. Hobby Lobby was filed, the challenge to the Affordable Care Act was based upon a particular federal law known as RFRA, R-F-R-A, the Religious Freedom Restoration Act. The Religious Freedom Restoration Act provides that government cannot substantially burden the exercise of religion unless the action constitutes the least restrictive means of serving a compelling governmental interest. Okay, do I need to say that again? Okay. There's got to be, in order for RFRA to strike down government action, there has to be a substantial burden on the exercise of religion. The governmental interest that promotes that burden has to be compelling, and it has to be the least restrictive mechanism for advancing that interest. You got that? Okay. I litigate both sides of separation of church and state and establishment clause, and I successfully litigated a number of years ago a case on behalf of kosher observant inmates in the state prison system who could not eat unless they ate kosher food, because that's their religion prohibits eating food that's not kosher. And I sued to force the prison to provide kosher food to kosher observant inmates, and won that case. And so, of course, you have an exercise of religion. The need, if you're going to eat, you need to eat kosher food. The compelling governmental interest is security in the prison. Oh, first of all, let's go, there's a substantial burden on the exercise of religion. If the prison doesn't provide kosher food, you can't practice your religion. So there's a substantial burden. We have a compelling governmental interest, security, and how are we going to provide kosher food when probably if we had 100 Jews in the room, we'd have 150 opinions as to what makes something kosher. And so you have that compelling governmental interest, but is the least restrictive means of providing security to prohibit in all respects the provision of kosher food. And I use that only as an illustration to show you how that test works. And I want to explain how RFRA came about. And to do that, we have to go back to 1990. And in 1990, a case came up before the U.S. Supreme Court, and that case, the title of that is Employment Division of Human Resources of Oregon versus Smith. And that case involved Native Americans whose religion required them to ingest peyote. And I can't remember how many Native Americans, but some of the adherents to this practice were fired from their jobs because they violated the drug laws. And they then filed claims for unemployment compensation. And I don't know what the Oregon standard is, but in Pennsylvania, even if you're fired, you are entitled to unemployment compensation unless the termination was for willful misconduct. And assuming that was the standard in Oregon, the question becomes, is following your religion willful misconduct? And prior to the Employment Division versus Smith, the governing Supreme Court probably would have held in favor of the people who had been terminated and wanted their unemployment compensation. Because there have been two prior decisions that were somewhat similar. The first was Sherbert versus Berner, a 1963 opinion in which an employee was fired for refusing to work on the Sabbath. And the Supreme Court held that that person who wanted to follow their religion by not working on the Sabbath could still get unemployment compensation. The other case that followed the same rule was the 72 case, Wisconsin versus Yoder, which held that Amish people did not have to comply with mandatory school attendance laws that require attending school in public school until the age of 16. Well, Justice Scalia didn't like those cases very much. And he established a new rule in the Smith case. And that is that neutral laws of general applicability, a criminal law, you can't take peyote, okay? That doesn't target one particular religion. It's a neutral law, and it's generally applicable to the entire population. Neutral laws of general applicability, according to the Supreme Court, are enforceable against religious practice, even if not supported by a compelling governmental interest. So Scalia, when we're talking about peyote-taking Indians, doesn't like the First Amendment so much, and he established this new test that was more deferential to government. Congress went nuts. And Congress then adopted the Religious Freedom Restoration Act, which was in direct response to the burdens placed on religion by the Supreme Court in Smith. And so that's how this Religious Freedom Restoration Act came about, which then kind of reverted to the old test. Substantial burdens on religion must be supported by a compelling governmental interest and enforced in the least restrictive means available. So here we have, now going back to Hobby Lobby, a law of general applicability, the provision of health insurance that covers contraception. and it applies to everybody. And it's mutual as to religion. So the government then, what the Supreme Court held was that the requirement violates the Religious Freedom Restoration Act because although there was a substantial burden on religion, the Supreme Court held there were less restrictive ways of meeting a compelling government interest, and that is that the government could step in and pay for the contraception itself, and it doesn't have to be provided by the employer. But what is more incredible for what the Supreme Court held there that poses a risk for all of us is that the Supreme Court, to reach that decision, had to hold that closely held corporations are persons under the Religious Freedom Restoration Act who are entitled to protection for the free exercise of the corporation's religion. The Supreme Court, though, and the danger, which I'll talk about quickly because I've been given the 5-minute warning and I want to get some questions. The real risk here is, will the Supreme Court in the next case extend that holding to publicly traded corporations? But the Supreme Court said it wasn't going to decide that question in this case. Now, in the dissent, what we have is exercise of religion is a characteristic of natural persons, not artificial legal entities. Justice Ginsburg quoted Justice Stevens from a prior case, the Citizens United case, who said that corporations have no consciences, no beliefs, no feelings, no thoughts, and no desires. Yet Scalia, who said the Native Americans couldn't take peyote, is now finding that Hobby Lobby has religious rights that supersede a mutual law of general applicability. And the danger is, what happens now if a corporation says, because of its religious objections, they don't want to fund vaccinations, blood transfusions, medical treatment, minimum wage laws, discrimination laws, the employment of free limit of women, or that certain racial groups are inferior and could only be hired for menial tasks. That's where we stand today. I could go on, but I've got the signal. I want to take some questions. So, who's up?
I just wanted to ask you if you can tell us where the Supreme Court finds the justification for separating corporations in general from closely held corporations, and what possible justification the Supreme Court could have for making that distinction.
All right. If you have a microphone, you probably heard is, what's the Supreme Court's justification for distinguishing between closely held corporations and publicly traded corporations? And what Justice Alito wrote in the opinion is that closely held corporations, especially the ones that were before the Supreme Court, were very closely held. You had single-family corporations. There was Hobby Lobby, and there was also the Conestoga Wagon case, which was a family-owned business. And what Justice Alito tried to do, which is addressed in the dissent, and said that in a publicly traded corporation, the vast number of stockholders could vote down any type of advancement of a particular religious view that the board of directors might try to foist upon the corporation. I'm not sure I buy it, but he tried to distinguish between the way a closely held corporation is operated and a publicly traded corporation which has a fiduciary duty to protect the interests of the stockholders, which may be a big variety of interests. So that's all.
So you have no justification, really?
Oh, I have no, legally I can't see any justification. Which is why the next case, it might be so easy in the next case for the Supreme Court to do something we call bootstrapping, to now, since it's decided closely held corporations can operate this way, it's a much smaller step to say that publicly traded corporations can operate the same way than in one decision to go from point A all the way to publicly traded corporations. Next question.
I just had a comment. It seems more and more like the Supreme Court, especially with Antonin Scalia, he's becoming a caricature of himself. And the reasoning behind their recent decisions, Lilly Ledbetter, Citizens United, Hobby Lobby, is just bizarre. And when I look at the block, the voting block, and you take Kennedy, Scalia, Thomas, Roberts, and Kennedy, I mean, these are 5 Catholics. And it's hard for me to believe that they don't let their religious beliefs influence their decisions.
Thank you.
It seems to be your position that it's a good idea for everybody here to pay more in taxes, pay more in healthcare premiums, so that the Hobby Lobby and all the big religious universities and all the big religious hospitals can pay less. And could you just explain that again? Because it seems to me there ought to be just one law that applies to everybody.
Well, the less restrictive means of providing contraceptive services that Alito wrote about, in part by saying the federal government can provide that, means that the burden, the cost burden, is passed on to everybody else. So yeah, that's one of the aspects of that decision, is to make everybody else pay for that as opposed to the corporation.
And you support that for the hospitals and churches and religious universities?
Well, I can support, I think that the law applies as the law was written, which would mean that the employers have to provide the insurance for their employees.
There was a friend of the court brief that argued that Hobby Lobby was not obliged to provide insurance to anybody. So if they objected to contraception, all they had to do was say, we're not going to provide health insurance. And I'm not sure how the court addressed that argument. I know it was made in the oral arguments.
Well, the Hobby Lobby decided it didn't want to sign the opt-out provision because it wanted to challenge the law. So that's what it did, was so we're not signing the form.
Okay, so 2 things. One, another example of a closely held family company is Home Depot.
Home Depot, Heinz.
Home Depot, Heinz, all of the big.
Closely held corporations doesn't necessarily mean small or local.
Yeah, I worked at Home Depot, and part of the initial training was, hello, welcome to the family. Anyway, the second thing is sort of not about this, but about a local issue. Particularly with Pitt and its discrimination against transgender students, which goes against the Allegheny County law, or the Pittsburgh anti-discrimination law. There's the ongoing court case, essentially,
I spoke to the lawyer handling the case last week.
yeah, but there's sort of a new thing. My roommate is part of that, and one of her friends is currently dealing with the discrimination at Pitt, and they gave her the list of bathrooms that she can use that are gender neutral, and they said there are 43 on campus, and she's going to them and finding that they don't exist. But she doesn't want to bring a case because she doesn't want to out herself and make it difficult to apply.
Well, if she doesn't want to bring
yeah.
the case, it gets difficult. I didn't know which case you were talking about. I spoke to the lawyer for the Johnstown Pitt case.
That's actually going to be my new roommate.
Okay.
So, sort of involved in that. Yeah, at this point, where does that, I guess, given that Pitt has sort of been given license to ignore the anti-discrimination law in Pittsburgh, how do you think Duquesne is going to do? Because I've heard, that's a religious college, and I've heard not great things about their anti-discrimination
religious institutions are exempt from many of the anti-discrimination laws, and I don't know whether the provision of the local anti-discrimination law applies to Duquesne or not, but it wouldn't surprise me if it does not cover Duquesne.
So many of us here would like to get RFRA repealed. Would that change things if that were to happen?
Well, if RFRA were repealed, it would give the government a lot more leeway to restrict religious practices and burden them. I think that RFRA actually is a strong protection. I do believe the Supreme Court misinterpreted RFRA in this case. I am not adverse to the government saying that if we're going to stop someone or burden someone's exercise or non-exercise, that the government has a heavy burden before it can do that for the individual.
Has anyone tried to pursue the argument that one of the primary purposes of incorporation is to shield from liability, and that therefore they're abdicating their personal responsibility and are therefore ineligible to be considered a person?
I do believe that argument was made in at least some of the briefs. I think it's addressed in the dissent. I don't recall for sure, but I think I read that. Certainly the whole purpose for incorporating is to protect the individual and say, you can't get to us. We don't count as individuals. You have this fictitious entity. So if the fictitious entity can't speak for the individual, I don't know how it can exercise the individual's religious rights, but you have to take that up with Justice Alito. Thank you very much. Enjoy the rest of the